Good morning, everybody, and welcome to the 20th meeting of the Equalities and Human Rights Committee. Can I ask that everyone switches off their mobile phones and puts them away? Agenda item 1 is evidence on the historical sexual offences, disregarded convictions and official records Scotland Regulations 2019. Can I welcome Hamza Yousaf, Cabinet Secretary for Justice, and his officials, Lindsay Mackay, Policy Officer, Criminal Justice Division, Scottish Government, and Patrick Down, Policy Officer, Criminal Justice Division, Scottish Government. Good morning, you're all very welcome. This item is a chance for members to put to the Cabinet Secretary and officials any points or seek clarification on the instrument before we formally dispose of it. The motion seeking the approval of the affirmative instrument will be considered at item 2, and I refer members to paper 1 in their pack. Cabinet Secretary, can I invite you to make an opening statement, please?
Morning, Convener. Thank you for the invitation. I'll keep my remarks brief. The regulations that the committee are considering today are an important final step, final step in implementing the Historical Sexual Offences, Pardons and Disregards Scotland Act 2018, which comes into force on the 15th of October this year. Members will recall that the 2018 Act provides for a system of disregards where applications can be made to the Scottish Government for convictions to be removed from official records if certain criteria are met as laid down in the Act. The purpose of removing convictions is to ensure they can never appear in any future criminal record disclosure check. The purpose of these regulations before the committee is to provide for the different means by which the disregarded convictions may be removed from official record. Flexibility in the method of removal is important because records relating to historical convictions are in a range of different formats where straightforward deletion of the record may not quite be possible. For example, information about a disregarded conviction may be kept on a physical microfiche document. With a document of that sort, it might not be possible to delete material contained within it. That is why the regulations therefore provide that a disregarded conviction can be removed either by deleting the record, redacting the part of the record which relates to the disregarded conviction, or annotating the record so as to make it clear that the conviction has been disregarded and it should never be disclosed in response to a request for information about a person's convictions. The regulation also specifies the bodies who are to be treated as relevant record keepers, with responsibility for removing information about such convictions from official records held by them following a successful application for disregard. Relevant record keepers are organisations that may hold information about disregarded convictions, which could, in certain limited circumstances, be disclosed to a third party seeking information about a person's criminal history. The regulations provide that Police Scotland, Scottish Courts and Tribunal Service, the Crown Office and Procurator Fiscal Service and Scottish Ministers, acting in their capacity as holders of official records maintained by Disclosure Scotland, are to be regarded as relevant record keepers for the purpose of the disregard scheme. All of these bodies are content to be specified as relevant record keepers in this way. The removal of disregarded convictions is an important practical measure to address the discriminatory effect that these convictions can potentially continue to have on a person's day-to-day life by ensuring they cannot be prejudiced in future by their disclosure. I am, of course, happy to take questions.
Thank you, Cabinet Secretary. Does any committee members have any questions or comments?
Just one slight follow-up, if I may, Convener. Thank you, Cabinet Secretary. I'm sure I speak for the rest of the committee when I say you have the goodwill with this SSI, and I will certainly be supporting it. I just wonder, when you talk about the historic records, those which are contained on microfiche and other things, which are much harder to either locate or change physically or the rest of it, is there a sort of scale to that, or is that just a very, very seldom happenstance?
So, primary record keepers will be Police Scotland. So, primarily have the information that you'd expect on a person's convictions. In terms of scale in relation to deletion, redaction and annotation, if it's police records that are on an IT system, for example, deletion would be the easiest and simplest. In terms of scale, I'm not entirely sure. I have to look to officials to see if they have an idea of numbers, but certainly Police Scotland with their systems would have the most. In terms of the national records for Scotland, potentially Scottish Courts and Tribunal Service, those more historical records may well be kept on things like microfiche, which I have to confess I've never seen a microfiche in real life, but I'm sure there will come a point in time. Then annotation or redaction may well be required. So maybe Patrick might want to come in about the scale.
Sorry, before you bring in Patrick, I guess it wasn't clear in my first question. I'm just surprised to hear that there are still criminal records which are only held in that kind of microfiche context, and I was a bit surprised to learn that they've not all been sort of translated over to IT files. For people who are living, I understand if it's very historic and people who are dead, but is that still something that's ongoing or just not planned, or what?
Just a second, it may also be worth saying that, of course, families can apply for somebody who has passed away posthumously to be recognised in terms of pardon. They'll get a letter of comfort in that regard. So there is that element of things. But Patrick may want to come into some of the more detail.
Yeah, perhaps it's helpful to draw a distinction between the police criminal history system, that's the primary source of information about criminal records of a person, where my understanding is that it probably is all now on IT, and records held about historical cases by usually National Records of Scotland on behalf of the Scottish Courts and Tribunals Service, where we understand that occasionally organisations like, I don't know, the General Teaching Council for Scotland or Social Work Scotland, when they're doing background checks, can sometimes go to the court service for information about a person's criminal convictions rather than going to the police. Now, I don't know how common that actually is, and to some extent we may be addressing a theoretical rather than a real problem here, but in order to provide assurance that all the possible sources that people might go to for a person's criminal history, whether that's the formal disclosure check system, or whether that's bodies that have various powers to look into people's criminal history, are covered off. And yes, I expect that actually in practice it is almost exclusively the police records, but we can't be certain of that.
That makes things much clearer. Thank you.
Okay, Mary Fee, I believe you.
Thank you, Convener, and good morning, Cabinet Secretary. One of the things that was raised when we were taking evidence for this piece of legislation, and it was raised by Tim Hopkins, and I'm sure everyone round this table knows Tim Hopkins very well. And while he obviously was very supportive of this piece of legislation in the disregard scheme, he did raise the point that by deletion or redaction, it was important that we didn't rewrite history. Are you confident that what is being proposed and what is being done will not alter the history of what happened to men over the years in this country?
Yes, I think it's a really good point, and much time and respect as all committee members will for Tim and his views that carry clear weight. I think that's why it was so important for us to have a range of flexibility in relation to how these records would be treated. So, I mean, it was almost precisely the point that Patrick was making. Previously, people may go to National Records of Scotland, go on the microfiche, look at the microfiche documents that exist, and look at previous court cases from the 70s, 80s, perhaps even before then, and be able to see a pattern of laws that were discriminatorily used against gay men. And that's why, for example, annotation might be really important. So what you wouldn't want to do is delete all of those cases that took place, even if they were in the lower courts. Because if you deleted all that, people might say, well, what the heck is the problem? So that is why annotation, for example, or potential redaction, but I think in this case, the example you give, annotation, is so important. So I'm pretty confident with what we've got. We took that into consideration, and that is precisely why there's a degree of flexibility around how these records can be amended or deleted or annotated, redacted.
Okay, thank you.
Cabinet Secretary, just to be completely clear, when you were speaking about annotation there, the option for removal by annotation, that it's the Scottish Government's intention that any annotation makes it clear that the annotated material is to be treated as having been removed. Yeah.
Yes. Yeah,
Thank you for that. Okay. Any further questions or comments? Okay. Agenda item 2 is the formal consideration of the motion in relation to the affirmative instrument. The Delegated Powers and Law Reform Committee has considered and reported on the instrument and had no comments on it. The motion will be moved with an opportunity for formal debate if needed. The motion is that the Equalities and Human Rights Committee recommends that the Historical Sexual Offences, Disregarded Convictions and Official Records, Scotland Regulations 2019 be approved. And can I invite the Cabinet Secretary to move the motion, please?
Move the minimum.
No further comments from committee members? Cabinet Secretary, I don't know if you need to wind up or if you're content.
No, I'm content. This is hugely important SSI, and as people have already said, hugely important in relation to the Act, both the pardon and the disregards, symbolically important, but clearly important in practical effect for the individuals involved. So I'm delighted to move it in my name and hopefully get unanimous committee support for it.
Thank you. The question is that motion S5M1805 in the name of Humza Yousaf be approved. Are we all agreed?
Yes.
Agreed. Okay, the committee agrees. That concludes consideration of the instrument. The committee's report will note and confirm the outcome of the debate. Can I invite the committee to agree to delegate authority to me as the convener to clear the final draft of the report?
Yes.
Thank you. Thanks for attending, Cabinet Secretary, and we'll suspend briefly to change witnesses. Welcome back. Agenda item 3 is Female Genital Mutilation Protection and Guidance Scotland Bill, Oral Evidence. Can I welcome our first panel, Dr Emma Jackson, Senior Lecturer, Department of Nursing and Community Health, Glasgow Caledonian University, Andy Cyril, Head of Scottish Migrant and Refugee Centre, Just Right Scotland, and Dr Saffron Carlson, Senior Lecturer in Social Research, School of Sociology, Politics and International Studies, University of Bristol. You're all very welcome this morning. Thank you for being with us. Can I start off by asking you about your experience and knowledge of FGM and to say a few words on whether you support the bill's aim to strengthen existing legal protection for people, women at risk of FGM. Who would like to go first? Everyone's looking at you, Dr Jackson.
Right, thank you, and thank you for the opportunity to speak this morning. My experience is with both communities. I work as an academic who works with communities who are looking specifically at the processes of policy engagement and the research that is done on them as opposed to with them. And I have come to this panel evidence session because I undertook a piece of research which ended in February this year with the communities of colour, some of whom are the practising communities, this was a Scottish Government funded and EU social innovation funded project, research project, looking at the experiences, both the experiences of the communities within the process of which this is part of, as well as their own experiences as a community organisation. It was with Kenyan Women in Scotland Association, with the lead organisation who we developed it. It was a colleague, Judy Wasage, and I, who undertook the research. So from my perspective about I think the main issue about the process is that there have been challenges for the community with the processes, and I think I'm asking the community to recognise the expectations on communities within our processes, and that there are risks to them because of how they are asked to engage in the processes, and very real risks to them as a community. And I think that was very strongly from the research. And I think there's a feeling of being co-opted, and there's concerns about from this, although within the bill and the actions, and I think that the Scottish Government in not bringing forward the legislation in relation to the anonymity of victims, the duty to notify police, and the failure to protect those issues. They understand and respect and welcome your approaches within that. I think having worked with the women, although supportive to the statutory guidance, there are concerns around the reason for the protection order over and above the reasons why this is needed for FGM above the existing child protection. And the reason I come to it from this is because of how our systems position the experiences of women, particularly women from African diasporic communities, different to everybody else's experiences. And so which was part of the point of the way that the research that I do works, which is to function, to look at why is that perspective positioned as different, although the issue may be different, but why is that seen as different? Why are the solutions that we have already in place around child protection in particular requiring something specific for FGM?
Thank you. That's very helpful, and we will come back to these points. I'll bring in other panel members. Dr. Carlson.
Thank you very much for inviting me to join the panel this morning. So I've spent about the last 20 years doing different sorts of academic research, looking and trying to better understand ethnic and religious inequalities in a range of different social sort of phenomena, health, and socioeconomic status and other sorts of experience, both in terms of the sort of outcomes from people's lives, lived experiences, but also the impact on their sense of groupness, their group identity, and the interrelationships between those. The particular research that brings me to this panel is some work that I did as part of a team at the University of Bristol and Cardiff University last summer, to look at the experiences of ethnic Somalis living in Bristol with FGM safeguarding services within the city. So this was a project that was sort of led by the academics, but was motivated by a call from local Somali groups regarding their experiences of these services and what they felt to be sort of very negative experiences, which they didn't feel were finding voice within the conversations that were sort of going on amongst sort of policymakers and practitioners. So it was an independent, ethical, university sort of led study, but it was very much driven by the sort of the calls of the local community. Although the research itself didn't only engage with those groups who had called for the research. Obviously, we aim to take a much sort of broader position. And I'll sort of come on to talk sort of over the next sort of few minutes as we come to questions about what we found in that research. But I think my sort of feelings about the bill, which second a lot of what Emma has said, is that it's appropriate that measures are taken to protect those at risk of genital or indeed any other sort of form of mutilation, particularly without or when they're not able to give their consent. But I think our and other research suggests that there are a range of ways to provide this protection. And the work that we've done and others suggest that there's far greater potential for the involvement of FGM-affected groups themselves in the development of these policies than is actually generally realised, and I think that's for a range of reasons, again, that I'll sort of come on to in a minute. But also, importantly, that I think the policies around these issues can be much more effective if we do approach these policies in a much more collaborative way. So our research and other research suggests that some policy responses to FGM, which already are in practice in the UK and elsewhere, have led to the stigmatisation and criminalisation of many innocent families. And not only is this sort of problematic in and of itself, our research, which comes back to why I mentioned the work that I've done around sort of ethnic identities, it's actually directly undermined the relationships within those families, within those communities, but also with people's, it's sort of undermined, in our study, people's sense of Britishness, people's sense of inclusion in British society. So the things that we're talking about today actually have far bigger implications than we might sort of realise, and I think importantly than are necessarily really reflected in the bill as it sort of currently stands. So I think, none of us want a more divided society. I think you have a really valuable opportunity to develop approaches towards the management of FGM risk, which can be more effective in achieving our longer-term aims of ending the practice of FGM in the UK and elsewhere, but while also minimising these negative impacts that current approaches are having on people from FGM-affected groups. Our research suggests that people from FGM-affected groups are very keen to collaborate. They really want to be involved. They've tried to be involved. A lot of the frustration that there was in this study was that people felt it was a collaborative approach that had somehow lost its way. So I think there's real potential. There's potential in Bristol. I think there is most likely potential in Scotland as well, as Emma saying, to have more conversations around effective approaches to these issues.
Okay, thank you. Andy.
Thank you for the opportunity to be here today. I'm providing evidence from a legal perspective today, drawing on my own and my colleagues' long-standing practical experience in and expertise in providing legal information, advice and representation to women and girls who are seeking international protection and who have survived gender-based violence. We work with women and girls across a range of different issues in UK and Scots law, including immigration and asylum, child protection and human trafficking and exploitation. We sit on the Scottish Government's implementation group on the FGM, so that's kind of where we're coming from. Importantly, we're also the legal providers for the government-funded Scottish Women's Rights Centre. And through that, we have extensive experience in advising on and obtaining protective orders for women who are affected by gender-based violence, including forced marriage protection orders. Now, for the avoidance of doubt, I would echo what my colleagues have said about the use of the law as a tool in preventing and combating FGM. The law should be handled with care, I think. Our view is that a broader focus on creating broader change is required, and the law is only one tool in that process. That said, I'm a lawyer and I'm here to speak about the law. And we do believe that the proposals in the bill will improve effectiveness in the fight to combat FGM and safeguard those at risk. FGM has been a criminal offence for 34 years in the UK. To date, whilst making FGM a criminal offence has sent a clear message of intolerance, it's not controversial to say that a criminal response alone will by itself eliminate FGM. Obviously, we all know there's been no successful prosecutions brought in Scotland, and the first one in England was only a few months ago. We agree that FGM protection orders would be a useful and important tool. Our primary experience, as I've said, is in working with women and girls who have survived or are at risk of FGM through their interaction with the asylum process. I'm happy to answer questions on that today. Our view is that the existence of FGM protection orders would play a positive role in whether a woman or a girl is able to receive international protection. As I've said, we also work with women and girls at risk of other forms of so-called honour-based violence, such as forced marriage. And to some extent, many of the same cultural and social factors are at play in our view. And through the Scottish Women's Rights Centre, our solicitors are first-hand of forced marriage protection orders and the importance of this type of remedy. Because of this experience, we do believe protection orders will add value to the current approach, and we're happy to expand on the reasons why that is today. And the last thing I'd say is that our experience highlights a particular area where there may exist a gap or a barrier, and that is with the protection of girls who are 16 and 17 years old. Now, we acknowledge that the risks of FGM are predominantly directed towards younger children, but teenage girls, risk persists for teenage girls as well in our experience. The definition of a child varies in different legal contexts in Scotland. Our experience tells us that 16 and 17-year-olds are often caught in between the legal protections available for children under 16 and those for vulnerable adults. 16 and 17-year-olds operate sometimes in the middle. This makes the existence of specific protection orders, whether it's forced marriage protection orders or FGM protection orders, all the more critical as a tool for local authorities, for example, to keep all girls in their care safe. We believe that it is a vital tool for local authorities to understand when it can be used or must be used, and we look forward to seeing the statutory guidance in helping local authorities understand what their role can be around that today. And we're happy to answer any more questions.
Okay, thank you all for that. Dr. Jackson, you mentioned that you thought existing legal framework was there was enough there within child protection and adult protection to protect women and girls, and you also spoke about risks to the community and being involved in these types of things. Can you expand on that a little?
Yeah, I mean, first of all, I want to say my expertise is about the process. Although I undertook a research project related to FGM, and the specific reasons why I undertook that research, my expertise is about our processes here in Scotland around policy making and research. And so I'm particularly interested in the issues of racialisation and marginalisation of the peoples whose voices we should be hearing in order to make it. And so the issue around, my understanding is, is that the existing child protection is stronger than what it's about adding to it in a specific way. And the details of that I actually I don't know of, but I understand that the child protection are still the strongest legal framework around which this would sit. And so I'm interested in the reason why for FGM is this put forward specifically for FGM, if that is the case. And I wanted to just put that forward. But I also wanted to ask about to explain about the research that we did. So the research was to support the work of the existing women, but also for the women to look at the processes of how they participate in what becomes a consultation, what becomes this framework. And the consultation call came during the lifetime of the research. and it actually gave the women an opportunity to try to respond collectively because of the project that we were developing at the time. And so, but it was complex for them, and I think that to try to articulate their experiences in that time frame, and I think there's real issues about how the process enables them to have their voices heard within it. And I think just one of the things that came out very clearly is that we are all learning here. We're all learning about how to engage in this issue. The women themselves are learning, but we as policymakers, researchers, academics, politicians are learning how to engage with this issue, particularly in Scotland. And I think related to that, and which came very clearly through whose knowledge is viewed as expert within this process. Whenever something, which is one of the reasons why I took the research project forward with the community, is that because of the intimacy of the issue, because of the uniqueness, because of the change within Scotland, because of the demographic change, it actually highlights many of the processes surrounding our processes here in Scotland, because we're not used to engaging with these issues in this way. And so the research was developed with the community to help us all try and understand how they experience engagement in our own processes. And I think one of the reasons, and I wanted just to quote from some of the pressures on the community when they were asked to participate, was said, it's one of the women in the research that is in my head, I cannot do this on my own. I wanted to open it up so that there's a group. I wanted, you want to be with other sisters. You want to think this is a real important decision-making process here. They're going to put it as law. You don't want to have to take that single decision by yourself. And I said to myself that how can we three of us sit here and even make these decisions? So to me, the importance of this was that the speed, the timing, the thinking required, the support needed for the women to be able to speak to the issue. And I think this issue around FGM, I think in the processes that we have to create it, one of the clear things that came out of the research, was an intergenerational research. It had older women working with schoolgirls and how they can support each other from practicing communities or potentially practicing communities, or people who've come to Scotland to live here. They were from Notre Dame High School in Glasgow, who were able to be supported by the older generation of women who had an understanding and an experience about how to manage FGM within their communities. They were fighting against it, and how to speak about it with your families, with your friends, with your schools, within schools, with your best friend is a really complicated issue. And so our processes have to try to recognize something that we can just ask to happen is actually really complicated.
Thank you for that. Dr. Carlson.
Just to follow up on that point, I mean, within our research, when they were talking about the policy, I think you asked us to comment on the sort of potential equalities and human rights issues in terms of this bill. And I think some of the participants in our research felt very strongly that there was sort of evidence of racial profiling going on within the safeguarding, provision of safeguarding protection, which I think follows on from what Dr. Jackson has just been saying. So, I think, again, that's something that hasn't been the sort of reflection on the sort of gender discrimination and the need to protect women, but there isn't so much consideration around some of these concerns in the bill as it currently stands. And I think it's something that the committee need to be mindful that they will need to sort of mitigate. And I think part of that is considering and reflecting really carefully on how this bill will add to the current protection for sort of different forms of child abuse. So people in our study felt that they were being identified because they were Muslim and because they were African, regardless of any sort of established level of risk to their children. And there was a very sort of serious question. So why do we need this additional attention? Why do we need this additional surveillance over and above all these other people that are all doing all these other horrific sort of things? So, and as well as sort of reflecting on that carefully, it may be that that there is still a very clear purpose for having a very specialised bill in this way, but being really clear about why that is, I think, would be very useful. So showing how this bill provides the additional coverage that's needed over and above the current legislation, should that be the decision that's made. I think something else, you asked us to talk about prevalence. I have another bit about prevalence in terms of the sort of figures from sort of parts of Africa and Asia which are generally used, but also most of the cases from our research looking at prevalence of FGM within the UK is that it's particularly among the under 18 resident population, is that in most of the FGM that happens is genital piercing, and that there are also rising rates of cosmetic labioplasty. These are all considered part of the sort of the WHO FGM types, but they're very clearly absent from the bill. And again, so this raises a question: why is this bill only focusing on practices which are considered originating in Africa and Asia, particularly given that some forms of pricking or scraping could be considered much less mutilating than genital piercing and some of these things that are absent. I don't know the legislation particularly well, but there are some suggestions that actually the FGM 2003 Act doesn't include some of these what might be considered less severe forms of intervention.
I'm going to bring in some of the committee members, if it's okay. Alex Cole-Hamilton and then Angela Constance.
Thank you very much, convener. Good morning to the panel. Thank you. I found this incredibly illuminating. I have a couple of specific questions on some of the evidence you've already offered the committee. Dr. Jackson, if I can start with you. You referenced, and the convener also followed this up, that child protection provisions might be enough to deal with the issues that we're talking about. But we had a briefing from the Bill team to suggest that FGM is not limited to children, and that sometimes, particularly after childbirth, a woman might be mutilated again. Are we wrong in that assumption? And is it solely an issue to do with children? I'm
afraid I wouldn't be able to answer that directly. I understand what your question is, but I don't think I have the authority. I'm not sure of all the legal aspects of it in that way.
So I just to, I suppose, expand slightly, is that this bill is about preventing FGM for everyone, and that we need to have confidence that everybody is protected by the laws of this land. Nobody over the 18 is protected by child protection legislation. Yeah. So I guess that's what I'm trying to bottom out.
Well, I would have to say that I'm uncertain. I would say that I'm uncertain of where that reach actually goes to, and that the risk or the challenges of the tool of the bill and the effect of that on the work that's going on in other ways to engage and to develop. So it would be, that's a decision that has to be taken, but I guess I'm just...
That's absolutely fine. You also sort of inferred that that this would make the cultural communities, would single them out. This idea of a protection order, it seems quite unique on this issue. There are, however, examples of other kinds of protection order that this Parliament uses quite readily. I think, for example, the risk of sexual harm orders, for example, which prevent young people and vulnerable adults from being groomed sexually online. That is an example of another group being singled out. It is a necessary tool of protection that the laws of this land, that we as lawmakers try to extend to vulnerable groups. Would you accept that?
Yeah, I accept that, but what I say that my work and my research comes from a perspective of looking at how the system, however it intends to function, can create experience of marginalisation and racialisation that it did not intend to happen, but comes from the approach that it takes to specific issues. And I just wanted to highlight that this is an area where we have to be extremely careful around what we are doing here because of those issues. I mean, one of the issues for me, for example, is that in the even in the documentation that came with us, and I've read many documentation, and I haven't always seen sort of graphic examples from, I mean, I don't know how many, but the examples, the diagrams and the explanations, which is so helpful. I just wondered about, is that usual practice within the sort of submissions to committees, and the sort of how those issues can play out in. So I'm not sure. Maybe that is usual practice, and to explain the issue in that way in the documentation which was received.
No, I'm grateful for that contribution. I think it will inform the tone with which the committee will proceed. I think we recognise that we have to do that with a heightened level of sensitivity in this area. I have one final question, Camino, and that's to Dr. Carlson. I think you've opened up a really interesting point there about the vast majority of female genital mutilation in this country is actually consensual. It's actually sought out by the individual themselves, and whether that's piercings or labiaplasty or anything like that. Is the issue, the difference here about consent and about the fact that that if it's a conscious decision by somebody who is over, who has attained maturity, that there is a disaggregation of those two kinds of FGM, and do we need to reflect that on the face of the bill?
Well, it's interesting because that was going to be exactly my response to your question, to follow up your question to Imma, which that actually, if we're talking about whether child protection legislation is enough, surely this then, and also coming back to my point about, you know, why cosmetic labiaplasty and genital piercing and things may not be included in this. I know there's a written submission talking about whether we should have laws about the age at which people can have genital piercing, and I think these are all around who we appreciate as being in a position to provide consent and who doesn't. So generally we're assuming that those under 18, I think the evidence around prevalence of FGM is very problematic, as I will come on to talk about in a minute, but what does exist suggests that it is typically under 15s, under 18s, it's concentrated a first incident, sort of allowing for what you say about sort of further reconstructions, whatever you might want to call them, but it is something that tends to sort of happen during childhood as far as we can tell. But there's also this question about when we appreciate people being informed and responsible enough to provide their own consent. So if we're not including clinical cosmetic labiaplasty and genital piercing in the bill because we're assuming that those people are providing consent, it's difficult to understand why those women who might be making other decisions about what they do with their bodies when they're older, after having children or anything else, are not being considered in the same way. And I think these are exactly the sorts of questions that are being asked by people from affected communities and the people conducting these sort of research. But I think also sort of some of these concerns come from misunderstandings, what appear to be misunderstandings about the current prevalence. So you asked for information about prevalence of FGM within Scotland. You also acknowledge that there isn't a lot of evidence and that evidence is problematic. I haven't looked at that data particularly, but you have just finished a study looking at the available data within England and Wales. I'm also aware of some other research done in the UK and also in Europe. And all of this evidence suggests that the level of FGM risk is much lower than we generally assume that it is. Obviously, we have these figures. It's 98% of Somali women and girls at risk. That doesn't mean that we shouldn't protect those at risk, but we should also recognise that research, all of the research as far as I can gather, suggests that the majority of UK resident people, including those from FGM-affected groups, are not supportive of FGM and are very committed to working to end it. So we know that the very high, so in your bill, you say that there's a lack of evidence and then rely on prevalence rates from different parts of Africa and Asia and use that to extrapolate directly to establish a risk. So we have the number of women from these countries living in Scotland, the number of children that these women who may or may not have had FGM have had, and use that to make an assessment of risk. So this assumes that the risk in Somalia transfers to Somali mothers in Scotland and the UK, and also then on to their children. Actually, the research suggests that that is not that's not appropriate. So using these figures to establish a level of risk in the UK is not an efficient way of doing it. Again, that doesn't mean we shouldn't protect those at risk, but it very much shifts the balance in terms of the number of children that will be protected by this against the really serious impacts that it has on the innocent families who get caught up in this legislation, which we've researched. So particularly research suggests that people migrating to and living in the UK and other low prevalence countries, Sweden, Australia, other places in Europe, have much more negative attitudes towards people living towards FGM than people living in the countries they moved from. So basically these cultures are changing. It may be that the people that move have much more negative attitudes towards FGM before they move. It may be that once they've moved into the sort of environment that we have and the attitudes that we have towards FGM in this country, that people are stigmatised for having FGM in the UK in a way that they're not elsewhere. And if we reflect on it in that way, that gives a very different sense of the sort of the scale of the problem. I mean, one is too many, but we're talking about many fewer people than we thought.
Thank you. I'm conscious that we're into the last half hour, and I want to make sure that all committee members get a chance to come in. So I have Angela, then Oliver, then Fulton. So.
Okay, thanks very much, Convener. I've got 3 questions, and I hope I can direct them to the appropriate witness, because I think for committee to do our role, we really need to focus and distill some of the issues. Dr. Jackson, you pointed out that as practitioners, as policymakers, as politicians, we're just really learning the best ways to engage on this. And I wonder, do you think in terms of practitioners, health professionals, social workers, teachers, etc., that there is a residual anxiety and nervousness about beginning to engage on this? Are we still resistant to raise issues, talk about it, because people feel quite disempowered about not knowing the best way to do it? If so, how would guidance help with that?
Thank you for that. I think, yes, eradication of FGM will only happen if it's inspired by the communities themselves, and they know this. And the communities I've been working with have been working really hard to engage in this with such few resources, with such few, such little infrastructure around themselves to engage. And so service to support themselves to engage. And so your question about practitioners, policymakers, they're coming at this, and it's relatively new to them. There is anxiety. There's anxiety not only how to speak of it within the community, and this was really clear in the research with the young girls. They were tasked in the research to try to go home, to speak to their mother and to speak to their father and to speak to a friend about FGM, about the issue. And this was a huge process for them to learn how to speak. So the anxiety is not just for the service planners, but
I've heard that very loud and very clear in your earlier evidence about the needs for communities and how we need to be better tapped in to that and really listen. But my question was specifically about professionals,
yes.
And whether or not they have an anxiety, whether professionals worry that they would perhaps be accused of being racist or being culturally clumsy, and whether we need to help or not to address that.
I think we do need to address that, and my point really, which I was trying to get to, is that it is the knowledge and the expertise within the communities that will help us. We need mechanisms and levers in order that their perspective of how to speak of it, what to speak of it, and who has control of the decisions made around it is with them. And I know we're trying this in other areas in Scottish Government. I see it with the child hearing, with poverty action, and we need it here. We need it desperately in here in order that those policymakers, service planners can become confident. The women are confident with support about what they're deciding. They don't always need, like, the committee, the NAP, even the National Action Plan Committee, how it was set up. There was 3 community members on that of 16, I think, who engaged in it. They saw that in the research, the women spoke specifically about how that balance already offsets whatever they produce.
Paraphrase you, Dr. Jackson, you can correct me if I'm wrong. What you're saying is we need to start really listening to the community and really ensuring that their lived experience is baked in from the start to our policy and legislative responses. Okay.
Yes.
Is that, if I...
Yes.
Right.
We have to trust them, trust they know it.
Okay, thank you. Mr. Searle, you're the lawyer, so I want to pick up on some of the issues in terms of our children's hearing system. And yes, the FGM protection orders are for children and women of all ages. What I would like to hear your view on is whether or not you think the children's hearing should be able to grant an FGM protection order. We know that the courts can refer back to the children's hearing system. I'm a bit concerned, personally, about folk bouncing around between 2 systems. I know there are a range of civil orders already, but is there an argument or not for the children's hearing system having an FGM protection order as a potential disposal or not?
My position would be that the existing tools within the children's hearing system, compulsory supervision orders, etc., are already sufficient if properly applied in order to do the job here. And I think that's an important point related to what Dr. Jackson has already said about us really needing to not racialise this issue. And so I think that for younger children who are before the children's hearing system, the existing procedures may well be sufficient if they are properly applied. The problem is that the children's hearing system only goes up to 16 years old.
Give me, and I heard that evidence loud and clear about 16, 17-year-olds, and that's certainly something I'll come back to with my colleagues in committee. But are you saying then that in the first instance for children under 16 and ideally 16 and 17-year-olds, the first place of reference, if a legal route is being pursued, should be the children's hearing system as opposed to an FGM order?
The children's hearing system is a specialised, child-friendly legal process. It was designed for the specific reason of trying to keep children outside of extremely adversarial sheriff courts and whatnot. So I think that if that's on the basis that that is a strength of the system, then we should keep it within the realms of the mechanisms that are already in existence there.
Okay. And my final question, Convener, because I am very conscious of time. Dr. Carlson, I wonder if you could summarise the things that we should learn from the Serious Crime Act 2015, so there's a few years based on the experience of England and Wales that we can actually benefit from. And I wonder if you could summarise from that learning things that we should definitely do in terms of this proposed legislation and things we should definitely not consider doing based on the experience south of the border.
So that's not actually my area of expertise. So I don't feel in a position to respond to that act. But I do have something that I'd like to say in response to your the questions directed to Dr. Jackson, which is about the professionals, and it does relate to some of the more specific things that you can think about. So I think some professionals are concerned about being seen to be racist or Islamophobic. But I think, coming back to what I was saying about the prevalence, something that we participants in our study felt very strongly was that professionals are far more concerned about missing children and not protecting children in their care. And actually sometimes that led to a tendency for professionals to sort of jump to conclusions out of a genuine desire to sort of protect the children, but that actually this meant that many more innocent families were being brought into the system than was necessary. So I think something that would be very important in terms of the bill is to be really clear about the guidelines for professionals so that they're very clear, the implementation is very straightforward, so that families aren't being referred without a reasonable level of concern, a level of concern which is established from communication with the family regarding the individual cases and the individual risks. So, for example, some of the risk factors that you outline, coming from a family with heritage from FGM-affected countries or communities, going on prolonged holidays even to FGM-affected countries is not an adequate point of establishing risk, as far as the FGM-affected communities are concerned, but also in terms of much of the sort of policy makers and the policies that are developed, particularly in Bristol. You have a number of other sort of potential risk factors in there which are much more sort of ambiguous. So I think bearing in mind that conversations about becoming a woman may involve conversations about menstruation, secrets can be surprise birthday parties, they can be presents. We all have secrets within our families. We all have conversations about becoming women. It's about and recognising that some of these aren't suspicious and they may not be related to criminal activity is something that's really important.
Council,
yes,
some of my
fine.
colleagues
That's as much as I was
might want
say.
to explore issues in and around risk assessment that professionals undertake. I think that's a really important issue you've raised. So I just wonder if we could turn to Mr. Cyril or maybe Dr. Jackson in terms of what we've learnt from the implementation of the 2005 Act south of the border. What are the top 3 lessons from that about what we should be doing and what we should definitely not be doing? And I don't know who wants to start, Mr. Cyril or Dr. Jackson.
I'm happy to contribute to that question. Obviously, was your question about the implementation of the 2005 Act? Is that what you said?
Yeah. So the Serious Crime Act 2015
England and Wales legislation
had FGM provisions, and it applied to England and Wales only.
Yes.
It's obviously had a few years of being implemented, put in practice. Is there any learning from that? Yes, no, and what is it?
Well, the 2015 Act obviously has multiple provisions in it which the Parliament consulted on but opted not to go for in the end: anonymity, offensive failure to protect, etc. The reason we came down, for example, against a specific anonymity provision for people at risk of FGM and against the offence of a failure to protect and against the duty to notify is that with respect to the last two, we didn't see any evidence from England and Wales that these were effective measures. What we have seen is that there have been a pretty high number of FGM protection orders in England and Wales. The numbers are quite interesting in the sense that you can see that I think between July and September 2018, there were 36 applications and 40 FGM protection orders made in England and Wales. Since they were introduced in July 2015, in that time 296 FGM protection orders were granted. Now, if we compare that to, for example, forced marriage protection orders in Scotland between November 2011 and January 2017, we 12 granted. So there's clearly a difference there in terms of the numbers of these types of applications being made. I appreciate that the issues are separate, but there are some commonalities between them, and I think that perhaps there is learning to take from approaches in England and Wales, good practice and bad practice, in order to make sure that this tool is actually effective. And if it's not effective, then we shouldn't have it. There has been research done recently, 2018 research done called Perception and Barriers Reporting FGM down in England, which goes through a list of barriers and gaps as described by interviews with 14 survivors. So I would refer you to that report. I can't really speak beyond that.
And other committee members and we can panel members can pick up on these points. Oliver.
Thank you, Convener. I first wanted to ask Dr. Jackson, I'm listening very carefully to what you're saying. I mean, obviously the bill's now published. There's been a lot of work done on it. We're here as a committee. You're here sort of talking about it. What do we do now to kind of capture some of the points you raise?
Well, and I was going to ask you, which is partly what my research does, is that I wanted to ask, I don't know the capacity within the statutory, with the statutory guidance, how is this then developed? How can we bring in what we're talking about here needs to be bring in to develop the statutory guidance? Or what opportunities are there within the processes, of which I don't know really what the processes are, but I want to know how the process that exists to create statutory guidance can enable the people I'm speaking with, the research sorts of communities, can affect what becomes the statutory guidance. And
that's really, yeah, that's really helpful. So you think it's in the statutory guidance?
Yeah.
As it's been developed, we really need to hear the voices of lived experience.
And to lead on how to do, I don't know if there's how creative, imaginative it can be to try to do it, but these are the places that the decisions are already made about what constitutes whatever this thing is that we're all talking about becomes. And that's a really important place, and it must not be the people, voices who all this work's trying to bring in, who aren't even there when that's made, and traditionally I think that's what happens.
Okay, that's helpful. On a broader question, I guess, for all three of you, is why do you think that there have been so few prosecutions under the existing legislation? And I guess connected to that, in England and Wales, in that context, why then we've seen people coming forward for protection orders, but not necessarily the prosecutions to go with it? What's the difference there?
I find that question very difficult to answer. I'll be honest and say I don't know. I don't know why there's never been a prosecution, a successful prosecution in Scotland, and why there's only recently been one in England. The answer I suspect is rooted in interactions between police, local authorities, and communities, and the barriers towards reporting, lack of trust, etc. But I am not an expert in those issues, and I would defer to my colleagues on this panel and possibly the next one as well.
Does anyone else have any comment on that? Why people don't see it as... why we don't see prosecutions?
I think it's important to say as well that the one successful prosecution was not of a family that had any heritage in an FGM-affected country, which also links back to the problems with the risk factors I was mentioning. Our participants said that the lack of prosecution is testament to the fact that it doesn't happen very much, and that actually there is all this investment to address what is essentially a very small problem. It's a significant problem, and by no means diminishing the impact of FGM on individual lives and the lives of families and communities. But that's there their response. And I think the other problem with assuming that it's a lack of police attention or enthusiasm or anything else, which has been the traditional response that we've had, is it encourages this sense that there's this sort of criminal underbelly of people committing FGM and trying to commit FGM if only they were given an opportunity, which really impacts on the ways in which those communities are responded to, both by different authorities but also amongst society in general. And this has really impacted on this sense of inclusion. It reinforces the distrust in all sorts of education, healthcare, police, legal services, social services. So it's just delicacy is absolutely imperative.
Why then do we see hundreds? I mean, I'm trying to ask it as gently as I can. Why do we see hundreds of people come forward looking for a protection order, or seek? I know that a lot of them are sought by police and local authorities, but why do we see those numbers coming forward looking for a protection order if there isn't a prevalence?
I mean, I'm not in a position to sort of comment on that, but if they're not leading to prosecutions or if it's not coming forward, then to a layperson that might suggest something about the evidence. But I am not in a position to comment on that in any informed way.
Could I just quickly add a point on in support of what Dr. Carlson was saying? The vast majority of women and girls that we've worked with who have survived or been at risk of FGM are seeking protection, international protection, because there is a risk if they are sent back to their country that it may well occur. They are seeking protection from something in their home country. They're not necessarily seeking protection from something that will happen here. And I think that's an important point when it comes to stigmatising, when we're talking about stigmatising communities. The women and girls we've worked with don't want this to happen. Their community is being accused of the very thing they're seeking protection from. And that's a common thing across immigration and asylum more generally, but I think it's an important point to bear in mind.
That's really helpful. Thank you very much.
Fulton.
Thanks, Convener. Good morning, panel. I just want to say as well that I think that the panel's been very informative, and it's certainly, I think as Dr. Jackson said earlier, it's certainly helping me to shape my journey through understanding this. Dr. Carlson, you mentioned about the risk being low. How confident can you be in that assertion? And the reason why I ask that is during our pre-engagement process, I spoke to a group of people who were involved in this, and it was a very informative visit. But one of the things that they said was that some of the men that I spoke to in that particular visit said that, that they were 30, 40 years of age, and they'd lived in these communities all their lives and not realised it was going on until they spoke to other people, and then they became involved in trying to support and help and things like that in communities in Glasgow, in Edinburgh and other parts of Scotland. So if that's people that are living there and it's difficult for them to get an understanding of it, how can we have faith in any risk assessment of?
In terms of the risk assessment, well, I mean, the data that we have from which to make these assessments is quite a long way from what we would hope. One of the things that we'll be doing based on the research that we've just been doing is to make some recommendations in terms of how we can generate more effective sort of risk assessments. And at the moment, I mean, I can't say categorically, there are this many cases. Well, I can't even say there were this many cases, and what type they were and where they happened and things like that, because the data, particularly, the data collected as part of sort of government statistics and things like that, just doesn't enable us to say that. But we do have research studies done with different groups from FGM-affected communities talking about their attitudes towards FGCM and different surveys done across the globe that engage with the changing attitudes towards towards FGCM. So people talk about it as being something that happened in their past. It was something in their history, something that is not considered relevant to their lives, something that is not considered relevant to their children's lives. And part of the frustration for this sort of ongoing engagement with this sort of protection is the fact that they're just British people living British lives and wanting to go on holiday and visit their families and being prevented from doing that by a system that doesn't reflect on the way that their culture has changed in the same way that all of our cultures change all the time.
So do you and the other panel members think, moving that on a wee bit, that if we don't do...
For a second, you used the term FGCM?
Yeah, so obviously FGM is the phrase that's traditionally used in sort of statutory services. It's quite a loaded term, it's quite a problematic term. Other people use female genital circumcision, female genital cutting, and we sort of go with, we would prefer to use FGC, but for completeness. Thank you.
Yeah, no, I was just going to ask if based on some of the things that all the panel have said today and the discussions we've had, if we don't get this bill right in terms of bringing the community on board and going on from a previous question, is there a risk that actually that the risk could be pushed even further out of reach for us to understand?
I'm an academic, I work with the communities, my work all focuses on the experiences from the communities. If something, from my perspective, if something so serious that warrants this committee, warrants this legislation, then I have to look at what have we put in behind that. And even my research project, which I did with the communities, worked really hard to engage them, to develop trust, to support their own work. That ended. Where's that expertise gone? Where is it? Where are we let that something so important that has this bill, and yet the many, many community groups, the many people like me, a black academic in Scotland, working really hard to bring that voice through. I'm in project bidland time and where's the knowledge, the expertise, infrastructure? That's what we need to grow. And I don't know if the statutory guidance, I hope it can develop and to recognise what those, for our knowledge base in Scotland, for us to become knowledgeable, more knowledgeable about how to manage these sorts of intimate issues that are within our lives here, that we need to grow our mechanisms to be confident so the policy and processes know where to go to get it in ways that everybody feels confident about it. And so looking at how we fund these sorts of issues is really important. For this is, our demographics have changed forever. This is not something, this is something we need to really think about deep within our processes. That's why I say we're going to, and then we'll get the knowledge and the risks. And we are learning how to do it. So there are risks to what we do and how we process it, but to build the resources around so that 5 years from now, we're not saying that in the same way. Yeah?
So that was a risk that our participants actually raised. So we had anti-FGM campaigners as our participants, but also regular members of the community, all of whom were interested in seeing and keen to see the end of FGM. And they did talk about that. These are people, so people that are being referred from schools, these are people that are handing in their holiday forms to say they're taking extended leave. These are people who are ticking the boxes and filling the forms as they're being asked to. So the concern was that if you start criminalising these innocent families, people that actually do want to do this are going to go underground. But it's bigger than this. So we've had Somali-led anti-FGM campaigners for decades in Bristol. It's had a massive impact on education around FGM. We can't tell, obviously I don't have the statistics about the impact on prevalence, but it's been really significant. And the campaigners feel that that has caused cleavages. The FGM safeguarding procedures have caused cleavages within the community. They've undermined the work that has been done. The communities feel unfairly stigmatised, criminalised. It's undermined their sense of Britishness. It is encouraged their sense of living in a hostile environment. It's undermined their trust in services, as I've already explained. So it's not only about FGM, it's about the potential impact that this has that goes far beyond this specific legislation, but the ways in which it reinforces so many other things that are happening in society at the moment.
Yeah, Dr. Carson, I think we all hear that point that you've all made loud and clear. Annie, I know that your topic was sort of covered, but do you want to come in on something else? Or?
Yeah. Yes, please. Thanks very much for coming along, and I've listened with great interest today to everything that you've all said. One of the questions I want to know is, do you know of anywhere else that have, any other countries that have done successful interventions which don't involve legislation? Please.
That's a good question. No, I don't. But
No.
I'm not aware. Sorry, it's not my area of expertise.
I mean, I think educational initiatives are far more effective than sort of punitive ones. You know, if we want to catch criminals and protect children at risk, but actually long-term solutions are about community-led, community-engaged, collaborative education. So, you know, I think this bill needs to be part of an armoury. It's difficult to see from this how this bill would fit within your wider sort of services around FGM protection, but generally moving away from the punitive and towards the educational is the way to go.
Do you know of any other countries where they take a different route to the intervention of FGM?
Generally, it's pretty heavy-handed,
Right.
yeah,
Thanks.
and not very positive.
I don't have much to add beyond. I think in Europe, the most well-known country around this issue would be France, which pursues a pretty ruthless criminalisation, very high, the highest number of convictions in Europe, and I don't think that, and I think the panel may well agree, I don't think it's a particularly effective method. But again, that's just an observation from our own research.
Thanks very much. Thanks, Convener.
Mary Fee.
Thank you, Convener, and thank you to all the panel for your evidence, and many of the questions that I would have asked have already been covered, so I will be quite brief in the questions that I'm going to ask. And the first one is in relation to legal advice, and perhaps if I could start with Mr. Cyril. Should legal advice be free and freely available to anyone that comes forward with a query around FGM protection orders?
Yes.
That's very helpful.
Not just that, but there should be, and perhaps the guidance can help with this, there should be comprehensive access to support, legal and non-legal, including local authority support, but also referral pathways to access free legal information and advice. So it's not just about free access to a lawyer, but there should be broader access to legal information.
So it should be a kind of wrap round, doing everything that is required.
Yes.
And perhaps before I ask the other panel members the same question, given your background, how much weight is placed on the risk of FGM through the asylum process?
That's a really interesting question. We can take learning from England and Wales on that. The courts, the High Court in England and Wales ruled on this in 2017 and said that the Home Office, when they're assessing risk on return to the home country in the context of an asylum claim, are not bound by the existence of a FGM protection order, but must take it into account. And the Home Office have published guidance on this area, which states that it can provide very strong evidence in the context of a claim for asylum. Our strong view is that it would be helpful in the context of a claim for asylum if we're trying to demonstrate risk in the past, risk here, but most importantly, risk on return to the home country. If there's a forced marriage, an FGM protection order in place, it may well have elucidated further evidence. It will have produced a result on a higher burden of proof, and so it would be helpful in that context.
Okay. Thank you. Do the other panel members have a view on legal advice? And I would be grateful if you could, for as short an answer as possible, so I can ask my second question before we run out of time.
In truth, it's not my area of expertise, but you know, I completely support that there's a broad umbrella of support around. Yes.
Okay.
I'm very much in support for free legal advice and legal aid more generally. But I think something else that came from our research is the need to be really clear about those guidelines as well. So how do people access the advice, but also the pathways through. So the number of people that we had involved in FGM protection orders, it was about, I didn't know what evidence they had, I didn't know what was happening, I didn't know how long they were going to hold my passport for, I didn't know. Just this sort of lack of knowledge was really frustrating and problematic for families, so being really clear about that too.
And the second thing I wanted to ask about was guidance, and it's a word that's come up frequently in the last hour, and the use of guidance is something I kind of have a bit of a bee in my bonnet about, because I think guidance can be incredibly useful, or it can be a complete and utter waste of time. And there is already multi-agency guidance in existence around FGM. And I'd be keen to hear the panel's views on what guidance should come with this bill. Should it be statutory? I get what, Dr. Jackson, what you've said about consultation with the community, and it would seem really, really important that the community are heavily involved in whatever guidance is produced that comes with this bill, whether it's statutory guidance or not. But I'd also be keen on the panel's views on whether, in addition to the guidance, that something is built in to say that there should be ongoing community engagement, there should be ongoing education, and it shouldn't just be when there is perceived to be a risk, or when this bill is published, we do a bit of something in schools or with community groups, and then we don't do anything else. So I'd be keen to hear your views.
I think that's a really helpful question. I don't understand all the ramifications and potential of statutory guidance, but I know that this issue is creating ways of thinking and ways of engaging in policy that is requiring us to think differently about how. And so from my perspective, and from working with the women, from understanding how deep their knowledge is of how to engage with this issue, that we, unless we have them there as decision makers with the authority, not just consultation, with actually in there. So we have to rethink our own processes of who makes that guidance and whose voice is allowed to influence what that guidance becomes. That's where we can make real change in Scotland. And I think, as I said, I've seen it trying to happen in other committees in other areas, and I haven't seen it often happening around people of colour, around migrants. They're so far from it. It's allowed to happen in other areas. And I'm saying, here's an area, really look at this. And, you know, there's an opportunity here to do something.
Dr. Carlson?
I mean, yeah, I completely agree. I mean, I think communities actually, or the populations actually affected by the issues under discussion, need to be involved with the framing of the problem, the identification of the problem, the identification of the solutions, and then ongoing, whether you call it evaluation or just long-term collaborative co-production is yeah. And partly it's about undoing some of the issues that have, and the problems that have arisen through less communicative approaches. So being very proactive in being seen to be communicating, I think, would be very valuable.
Okay, thank you.
Yes, we're in favour of statutory guidance. We think that robust and clear guidance would complement the measures already in place in the bill. It could provide clarity around risk assessments, which should be undertaken in this area, and when legal orders must be applied for in terms of protecting children. Our experience even in the last 18 months in the area of forced marriage, has shown us that there are times where authorities have not acted, and the consequences of that have been severe. And guidance would help local authorities make decisions around that. The one last thing I would say is that when you're talking, I would adopt what my colleagues have said about community engagement within the guidance. We can't talk about risk factors in an issue so closely connected to cultural, social, familial issues without involving the community. It's not possible.
Okay, thank you.
Thank you all very much for your evidence this morning. That was really, really helpful. We'll suspend now for 5 minutes while we change over. Welcome back, everybody, and can I welcome our second panel to the committee. We have Jan Mcleod, who's manager with the Women's Support Project, Angela Vulgari, Gender-Based Violence Services Manager at SACRO, Anne Spears, Deputy Chief Executive Officer, Multicultural Family Base, and Hassan Darasi, Project Manager, Community InfoSource. Good morning, everybody. You're all very welcome. Some of you will have been here for the first panel, and we've obviously a lot to get through, so I'm going to try and be disciplined with my questioning, and so will all members, and we'll hopefully hear all that we need to hear. Can I ask, just as an opening, just for a brief bit about the work you do with FGM and your views on the current legislation, please? We'll go to Angela to start with.
Good morning, everyone. The reason we're here today is I started working with SACRO, who was the lead partner for the Bright Choices partnership. Bright Choices was a partnership between the Multicultural Family Base, SACRO, and the Edinburgh Lothians Regional Equality Council, which was funded by the National Lottery Community Fund between 2015 and 2019 to provide support to individuals, families and communities affected by any form of honour-based conflict and honour-based violence. Under the umbrella of honour-based conflict and violence, we actually realised that there was an overwhelming need for support, both for survivors, women who had survived FGM, as well as for children who might be at risk of the practice in Edinburgh. At the moment, my colleague Anne Spears is here from the Multicultural Family Base, who was one of the key partners for the delivery of Bright Choices, and the FGM support and protection worker for Bright Choices is still placed within the Multicultural Family Base. So this is kind of our connection to this work.
Okay. Jan.
Good morning. Yes, we work, the main issue at the Women's Support Project is violence against women, and we became involved in work on FGM by being approached by women survivors of FGM who wanted to be involved in community engagement work because they believed that there was a significant number of people who weren't aware of the law in Scotland or of the negative impacts on women's physical and mental health of having undergone FGM. So through that, we got drawn into work at local and national level. And I think it's just really important to acknowledge that we're all here today because of the grassroots activism, especially led by African women. And we've tried to use that to guide our work. And I caught the end of the last panel when the involvement of communities potentially affected and women who've experienced FGM has been absolutely vital. I think as well we've been guided by sort of working within the wider context of violence against women and girls and human rights. And we've tried to stay very aware that although, of course, FGM is a serious form of child abuse and can, for some women, have lifelong impact in terms of their health, that when it actually happens, that in the vast majority of cases, parents believe that it is the right thing to do, or that it's expected of them, and that not carrying it out might have immediate negative consequences for their daughters. So that's, I think, a very difficult thing for child protection systems here to struggle with. So it also leads to an understanding that in order to work effectively with communities, or for communities to change, like community-led change, that you need to amend your approaches slightly. So, for example, if somebody genuinely believes that their religion requires them to carry out FGM, then the law might not change their behaviour. But if you can work with their faith and look at the fact that, as far as I'm aware, no religion requires or condones FGM, then you can get overnight change for people. So those are the sort of principles that we've tried to inform our work. And the actual work that we've delivered has included developing resources and training materials for practitioner training and public education, We've supported networking between statutory and voluntary and community sectors through like newsletters and meetings. Last year we had a national conference with a trauma focus, and we've done a small bit of community engagement, and we've always tried to do that in partnership with BME or survivor-led organisations. So we've worked, for example, with Quisa, the Kenyan women in Scotland, who've done some absolutely excellent work in communities, with Hassan, the Community Information Source, Sahelia, the Violence Reduction Unit. And although we don't have funding for a support service for women, because we're involved in the public education, we do get gradual trickle of referrals from lawyers, social workers, health visitors, and we're aware of the lack of services for women.
Thank you very much. Anne, if I can come to you next.
Good morning. Thank you for inviting us along. I work for the Multicultural Family Base, and we're amongst other things, we're a social work training agency, so we work with social work students from all over Scotland. And we provide family support services to for not to adulthood, actually, across our various different projects, for Black and minority ethnic communities, and we've always had a focus on communities that are new and emerging, or peoples who are moving to Scotland. So our first communities 20 years ago would have been Sikh and Pakistani communities, which are obviously very well resourced these days and self-supporting. So we work with a lot of refugees and asylum seekers at the moment from Syria, for instance. As Angela's already said, we were part of a bigger collaboration, a partnership, a philosophy that was called Bright Choices, and we are currently, as Bright Choices, have in place our FGM support worker, who works with women and girls and families, and part of the Bright Choices, part of MCFB is also our honour-based violence support worker. So we have 2 workers in place that work specifically with those issues, and obviously if that was a Venn diagram, there's quite a big overlap between those 2 issues. So yes, that's us.
Thank you. Hassan.
Yeah, I'm Hassan Darasi, project manager for Challenging Violence Against Women in Community InfoSource. Community InfoSource, the community interest company, started in 2006, which has the legacy of working with disadvantaged communities, especially from the Black and minority ethnic groups. And they are one of the people who have benefited from Community InfoSource when I came as asylum seeker, and where we started our Scottish Asylum Seekers Association, which is unique in the UK, where the asylum seekers were the tenants and the landlord was white people on that time. And we have been working in a lot of projects, like pilot projects like Living Well in Glasgow, through Community InfoSource. And we work with partnership like with Women Support Project, with Jan, which we have benefited a lot in our project. And while we're doing those kind of things, a need came for working with men. So this was actually brought to one of our partners, Sahelia. Since they only work with women, they said that we are going to, give this work to Community InfoSource, who work with all genders. That's why we tapped in. So we work in a very challenging environment where we work with men, where we are dealing with men from East Africa and West Africa, as well as some from Middle East, because there are many people from Middle East who also practice, this FGM, like Yemen and Kurdistan in Iraq and others. So it's very challenging work. So we work with men, and why the need came working with men is because if you are going to do away with FGM, working only with one gender, you stand a little chance of getting away with it. So the involvement of men was very important. So that's where we come from.
Yeah, thank you, that's very helpful. I'm going to go straight to committee members for questions, and not everybody has to answer every question, but obviously if you wish to contribute, you can. Oliver, I'll start off with you, please.
Thank you, Convener. I'm interested, we heard from the last panel about how the protection orders had worked in England and Wales, and I kind of note that only 3% of those orders were made at the request of the person to be protected. How do you think that we, as we bring forward this in Scotland, how do you think we empower more people who are directly affected to kind of come forward and seek protection themselves?
Through education, first of all. The approach that we have taken as a partnership and many other partner organisations around Edinburgh and Glasgow have taken is not about jumping in and telling people what to do. It's about making sure that people are on our side through an understanding of why FGM is a damaging practice, what are the lifelong effects FGM is going to have on a child and later on in the girl's and the woman's adult life. And a lot of the time, once people do understand these impacts, it becomes a lot easier to actually get them on our side, to actually agree that, yes, this is not the future I want for my child, and I'm prepared to work towards protecting her. And I think, you know, to a large degree, I believe that my colleagues will agree to this as well. It's about education, raising awareness, and making sure that people understand we're here to support, not to punish.
Sorry, Jen, do you want?
No, on you go.
I suppose my question back would be, just to clarify, the original question, Oliver, was how would we encourage people to engage with protection orders themselves or seek those themselves? Is that what you're asking?
That's sort of the thrust of my question, because I think in England and Wales 39% of orders were sort of requested by the local authority, and I think 58% from the police or other sort of third parties, and it's just, I think, reflecting on the first panel's evidence and sort of some of the evidence we've had, it's just this feeling that this is something that's been done to communities rather than people themselves coming forward and having confidence in the process.
I suppose my starting point and discussions with my colleagues on the run-up to this, we have some questions, as did the previous panel members, about whether the protection order would not necessarily be required, but how much in a way of teeth it would have, and whether it would be useful in addition to orders that already exist, such as child protection orders. And obviously some of those orders we're more familiar with at multicultural family base. If we could go back the way we'd want to change the title and call it a protection and support order, because I think if we're asking people to come forward themselves and request something, there needs to be something in it for them. And our experience of intervention is that that's best received when it goes alongside tangible support to people. So if this offered people support as well as protection, because our view is that if you have a child, for instance, who is at risk from FGM, and I also take some of the points that our previous colleagues made about the prevalence of that situation, but for us, in working directly with people who are actually affected by FGM, if you have a child who's at risk, you have a circle of people around that child who are also at various levels of risk as well. And if one of the additional risks to them is of prosecution or criminalisation, then they won't come forward and they won't engage. Who would? Because if you're likely to put your other children at risk of a parent being prosecuted or criminalised in some sort of way, then the hope to have people engage with a protection order on that level is reduced, I would suggest. And I think that's one of the areas that we have a lot of concerns about. If we're offering protection and support, then there's a better chance that people will engage more readily with that.
Yeah, I mean, I would agree with both replies so far, that when we had meetings with women from communities affected by FGM and asked about the protection orders, the number one response was, you know, you can have as many laws as you like, but if people don't know about them or if they don't believe you're going to use them, then it doesn't matter what the law says. In relation to the specific question about how could we increase the number of people at risk who are actually applying for it, I think obviously the first thing is that they need to know about it, and I can imagine situations where young women or adult women who are at risk, because there can be a risk for women. There can be a link with forced marriage, where in some cultures the FGM is carried out on the eve of the marriage. And the ROSA project research some years ago suggested that the age of protection should be raised to 25 at least, and I think that's an important gap in the way in terms of people's thinking. For children or younger women, I don't think the fact that somebody else is applying for it is necessarily a bad thing, in the sense that it's a huge step for anybody to take. And given the overlap sometimes between domestic abuse or honour-based violence or cultural attitudes, it can sometimes be a help for a family if they're able to say, well, it wasn't really us, it was that social worker that did it, or the police made us do it, because otherwise it can cause huge fallout in the family. And that was another thing that struck me about the discussions that we've had, where women will often say, like, a woman cannot say no to her husband or her mother-in-law or something like that. And it was really strong, you know, and especially relevant to a different point, which was the suggestion of, like, the failure to protect orders, and that was a huge concern in communities.
Thank you very much. And sorry.
Yeah, I would like to add something that I do agree to what my colleagues have said, and actually we have been discussing this issue with some other groups as well, and we had the same view like what Anne actually elongated called it, protection and support order. We didn't say it that way, but that I like that expression. What we said is the project actually welcomes these measures as a real contribution to the prevention strategy, which provides a deterrent and not just the present punishment order. And one of my colleagues said a nice expression on that time is, you know, if you are going only to punish, it is like, you know, closing the doors table after the horse has bolted out. So I think, you know, to make deterrent measures are far more important. People should be educated. We should make, you know, raise awareness in all the communities. And this is what is needed, you know. It's just jumping only to the punishment will not be ordered, though we are totally in, you know, we agree to make this protection orders.
And just to kind of follow on from that point, do you think people will see the protection orders as being sufficiently distinct from criminal prosecution, or do you think there's a sort of, do you think people see criminal protection orders as being connected to the kind of criminal process? Do you think that?
It's hard to judge, actually. I think the understanding of some of the legislation and powers that might be brought to bear could be quite minimal amongst communities. They certainly are in the white Scottish community about laws and legislation, in my experience. I think for all of us, unless something's specific to us, we might not have much interest in it. I think that there could be a deal of confusion. I think it would be more important as to how they're delivered and by whom and in what way, and would be probably more important to individuals and communities. I don't know if my colleagues would agree with that.
I think it is hard to say. I mean, certainly in discussions, people have understood what the orders are trying to do, like a sort of first stage, if you like, without criminalising parents and giving that opportunity to protect people without it criminalising your close family. So, I mean, I think if you look to the forced marriage protection orders, as far as I know, that's not a huge issue, so I would imagine it would be workable.
I need to follow up on that and then...
Thanks very much, Convener, and good morning, panel. We, as a committee, sent out for calls for evidence on the actual bill itself, and we received 13 submissions on this, and we're all pretty mixed around the additional protections that should be put on the face of the bill. 3 in particular come to mind: lifelong anonymity for the victim, failure to protect, and a mandatory duty to report. And I would just really like to get your views to think, should these be included in the bill, or is the bill going far enough?
the bill's gone far enough. I mean, for the failure to protect, we had huge concerns about that, and it came out in all the discussions that they might have like quite serious unintended consequences. And also, I'm not a legal expert, but it seems to be contrary to everything else that we do in terms of legislation. Like, how can you prove that you failed to do something? And going back to my original point, I have heard anecdotal stories where families, parents who don't wish to carry out FGM, who've gone back home, have come under huge pressure. And you could imagine a situation where somebody say, well, you should just have said no. But I already said, you know, women state that so strongly, like a woman cannot in some circumstances say no and be safe, or have her children be safe. So that one in particular, the one about anonymity, our view was that it's not helpful to pick out FGM when we don't have legislation round about child sexual abuse, incest, rape and sexual assault. So if there was something needed, that it should cover all victims of gender-based violence, males and females. Whether that's necessary, I'm not convinced.
Anyone else got anything to add to that?
We do also agree. Our view was that anonymity should be guaranteed lifelong for anyone, any victim or complainer coming forward for FGM, purely because of the further risks in which that would place them and the potential family members, community members, extended family, as a result of having spoken against this century, millennia-old practice. And there could be sort of further repercussions from the wider community. There could be all sorts of unintended consequences should the name of that person or that family actually be made known to the public. With regards to failure to protect, again, it was quite a divisive question in the sense that overall we responded yes, but the answer to this, it contained about 7 or 8 different considerations that need to be taken into account, because although we can see the benefit, it's not as simple as saying, you know, black or white, this is it. We need to take into account, well, in this particular situation, have we considered the specific circumstances in which this situation came to be what it is? And if so, again, as Jan mentioned earlier, how do we prove one way or the other? I'm sorry, I'm aware that you also mentioned
mandatory reporting duty.
The mandatory reporting. Again, that was another question where, you know, answering why took a very, very long time, because as Anne mentioned earlier, it's not just about making the reporting mandatory, it's about making the support mandatory to that child or that woman and the wider family and community. But also, there was a consideration of if we don't provide that support, then further generations and potentially other members of the family are going to suffer as well. So we need to take a step back and really look at both sides of the argument. It wasn't very clear, I'm sorry, but unfortunately it's not a very sort of straightforward response.
What my colleagues are saying, this issue has been discussed actually in the FGM summit back in July, and there were so many issues about it. And one of the issues was the failure to protect. This word is very elastic. You cannot define it. You know, what do you mean by failure to protect? And here maybe are putting even the victim in the same pot like the culprit. And like the other issues like anonymity and others. So I think the bill is going too much far. Well, you know, like issues discussing, like as I said, failure to protect, as well as there are no clear guidance. Even the third sector do not have any clear guidance on that. If the statutory, yesterday, on Tuesday, we have been in a meeting for National Action Plan here. Even the statutory bodies, they are not clear about all the things. So how do we expect communities to be clear about what the law says? And we don't know whether there would be some guidance also to the third sector. And, you know, the language is too technical as well. It will be very hard to deliver to communities. For example, we do it at the grassroots level, where the people, English is not their first language. all these technical words and other, it will be, I mean, very hard to conceive or to be understood by the people who are supposed to be, this law to be applied on them. And at the same time, there could be some, as well, profiling of communities or stigmatizing people as well. So if you are going to use only this kind of legislation to certain categories of people, then how do these communities perceive it? Though, as John said, it won't have much effect because like the forced marriage bill has also gone, there was not much thing, but that is only certain community from the Asian communities, not as a whole. This could be different than the forced marriage, so it could have an effect on the wider communities.
Thank you very much. Thanks.
Bring in Alex.
Thank you very much, Camina. Good morning to the panel. In the last panel, Dr. Jackson raised the interesting point that potentially there is sufficient protection covered in existing child protection legislation to make this unnecessary, or at least make the prevention orders unnecessary. But we'd heard a briefing, as I mentioned to Dr. Jackson in the previous, with the Bill team, that sometimes adult women are subjected to FGM. And obviously no adult is protected by child protection legislation. So I just wondered, could you talk firstly about prevalence among adult women, if you have that knowledge or that evidence? And secondly, whether you think there is another route we could go down instead of prevention order, which wouldn't single out these cultural groups in this way?
I think in terms of prevalence, like nobody can say for sure if you mean how many women in Scotland are affected by FGM, because that isn't collected anywhere, you know. Whether or not the FGM protection orders are absolutely necessary, I know that when we first discussed it at a multi-agency meeting in Glasgow some years ago now, there was a feeling that it was possible currently to effectively protect children. But as discussions have developed, I think I would be right in saying, certainly from the women and some of the workers from other organisations that we've discussed with, there is a feeling that the benefit of having something specific about FGM would bring to people's attention that this is very much an issue for Scotland and Europe now because of migration, and it's going to continue like that. And there has been various research done to show that sometimes migrant communities hang on to their culture and traditions much more strongly than in the home country. So I think we could certainly protect children and young people without it, but I think it might have some advantages to have this specific. And a particular thing that we have noted, and it's very problematic, and again I couldn't give you numbers nationally, is the fact that the asylum system and their approach to FGM risk is very definitely at odds with what you're all trying to do and what Scotland has tried to do in terms to prevent and end FGM. And if I could just quickly give you an example involving a woman who was married in her home country. Her people did not practice FGM. Her husband's family did practice FGM. They were Christian. They believed it was part of the religion, and it was rooted in other traditions. They also expected the women to be undergo FGM before her marriage, but her husband didn't want that to happen. So everything was fine. They brought up their family for 12 or 15 years. And then the husband died, and at that point the daughter was 11. The family had just arranged to come to the UK to visit the mother's sister, and they got an unexpected visit from the husband's family, who had the attitude that the husband had died prematurely because he had broken the family traditions, and that they could remove the bad luck and prevent any further bad luck in the family by restoring the traditions. So they'd arranged for the daughter to be married aged 12 and for the woman to be married to her husband's brother. So when she came to the UK, the key thing I nearly forgot to say was the daughter overheard this conversation. So when they were brought to the UK, the sister said, you need to go to a lawyer. And the lawyer in London told the daughter, you don't need to worry, you'll be protected in the UK. Since then, their asylum claim has been refused, and the mother's currently terrified to tell the daughter that it's been refused again because she's very concerned about her daughter's mental health. Now, when that family came to us, there had been a social work referral made, but months had gone by. So I'm very interested to know whether or not an FGM protection order, and I heard the response in the last panel, that if that would be something that would have some weight in those cases particularly, where it is not a potential, you know, a possible thing, it's actually was planned and yet still the claims failed. It just really makes me wonder what communities make of, you know, the fact that there's legislation put in place that's directed at their cultural practices, and yet another section of British society saying, no, you'll be fine, just move to a different town. So sorry that was a bit long, but I think it really highlights that point.
I think that's opened up several new avenues of inquiry for us, particularly around the interrelationships between our deliberations here and the UK immigration system. Can I also ask the same question that I asked the last panel, just about the reality that there is a spectrum here, that FGM is a spectrum. There is absolute brutal mutilation of young girls, which happens against their will, right up to women from all cultural groups who choose to undertake changes to their genitals, whether that's piercings, whether that's labiaplasty. Is there a danger that by singling out one cultural practice that we create an artificial racial barrier here, where actually there are cultural practices in our own culture which are not necessarily traditions but are more prevalent, and do we need to reflect that in any way on the face of the bill? And particularly around the issue of consent, I think.
Going almost back to the previous question that you'd asked, because I think there's a connection. I think one of the questions you'd asked was about protecting women as well as girls, and that the protection order might extend, or is intended to extend to women. I think when you're talking about people with, and you're looking at the concept of consent, I know in other pieces of legislation, adult support and protection, for instance, the issue of consent for adults is a primary consideration when you look at protection orders that are associated with that legislation. And I suppose there needs to be a difference between consenting women and offering protection to people with capacity, so that there's a choice involved in that. So that was kind of just going back to the previous question. Sorry, I've slightly lost track of what your second question was, because I was working on the one you'd asked before.
Whether we need to be more nuanced on the face of the bill about the spectrum of FGM, and maybe even refer specifically to the issue of consent, that if what is regarded by the WHO as FGM is undertaken with consent, that, for example, if it's labiaplasty or whatever, that is a different, we need to disaggregate that within the pages of this bill.
I was very interested in what our colleagues were saying previously on this issue, and I'm not sure I've got any answers, but certainly some of the discussions we've been having is about risks of racial and ethnic profiling being too much of a consideration when looking at protection orders in relation to this particular topic. I'm not sure if we have the answers to that, because clearly we're talking about people coming from particular areas of the world where that ethnic profiling can go hand in hand. It can look like that, but that's certainly a concern for us, because if you are talking about a spectrum, we've almost got the mild unconcerning area of that, and I'm not sure that at one end of that I'm not concerned about what causes people to be influenced to undertake cosmetic FGM, for want of a better term. So I mean, I would have concerns about that, but I certainly have concerns about ethnic profiling and racial profiling that our colleagues made earlier.
To clarify my point there, my question rather, is I think if we, the thought I'm sort of growing in my head about this and what potential changes to the bill is that if we were to explicitly refer to consent in the pages of the bill, you could cover all of that. You could remove some of the kind of racial stereotyping that we're worried about, and rightly worried about, by saying that this happens in increasing numbers of cultures, and most of it may be consensual or at the person's own decision. But there may also be times when a woman in our culture in Scotland is forced by an abusive, coercive husband to have changes to her genitals undertaken. Absolutely. And she probably needs protection as well.
I think to be able to do that is like changing the world, which I'm not saying if you could, please do. It comes up quite a lot in our training. It's one of the things that we ask practitioners to think about, is how, if you got challenged, you mentioned you're a social worker and you're saying to somebody, well, you need to know that FGM is against the law. And they say, well, how come if I wanted to, I could just go and get labioplasty? And it's... The bottom line is that I do believe that there are numbers of women, including young girls, who are eagerly waiting till they're old enough to be able to get it done because of the social and cultural pressures, and also the impact of pornography. I mean, like when I grew up, you very rarely saw pictures of genitals, and now young people are seeing it all the time. It's having an impact on girls who've had FGM, who didn't realise like how much they'd been changed, and it's having an impact on girls and young women about their body images. And I think there's a perfectly solid, strong argument that can say it's cultural pressures, different cultural pressures that are leading to the same impact. I do think, though, that most practitioners and just people generally are clear in their own minds. And to me, whilst there might be concerns about the reasons that people are having cosmetic genital surgery, it's not generally intended to limit women's sexual pleasure or control their sexual behaviour, which is a key thing, I think. And the thing about piercing, I think, is really confusing, because my understanding, and I might be wrong, is that the original wording from the World Health Organization, when it says pricking or piercing, that they don't mean jewellery. That it is part of something to either tighten the vagina or something like that. So that is really unhelpful now, and I think it makes sometimes, for example, when midwives are asking the question, it might be easier for people that are a bit uncomfortable is just to sort of focus on the jewellery side, and that's not really what that question is about.
Okay. I think that was interesting in your response there and helpful. I suppose the first thing that popped to my mind was we need to be careful not to be going, that stuff that's done in a cosmetic surgeon studio is fine, and that's a free choice that's being made, and this other thing is bad, because it's all part of the same structures where women aren't valued, isn't it? There's lots of colleagues waiting to come in. I'm trying to remember what order. Angela, I'll go to you. I
wanted to go back to the issue of anonymity, and I would be interested to know from Ms Volgara and other members of the panel, if they have a view, that in the context of this bill, should anonymity for victims be automatic, or do you have a view about how it would work in practice? And I'd also be interested in your views that the courts just now, under the Criminal Procedure Scotland Act, can indeed grant witness anonymity. There's 4 criteria that has to be met, and all of the criteria have to be met before it's granted. So I just wonder if you could tell me, since you support it, how you think it would work in practice, and whether or not you think the existing provisions that exist for the court to grant anonymity, whether they are sufficient or not.
With regards to automatic anonymity, again, to go back to Alex's question as well, we firmly believe that it should be provided immediately, not only because, a lot of victims are going to be children, but having said that, in our experience, we have worked women as old as 43, 44 years old who were at risk of FGM, and upon refusing to undergo the practice, they were at risk of an honour killing. So we need to kind of be very aware that, it's not just children that we're talking about here. We need to extend this provision to adult women, and similarly women in their late teens and early 20s as well, who were adults. With regards to another consideration, I suppose, that influenced this response was the fact that sometimes you don't need to state someone's name when you're a member of a community that can be quite small, quite tightly knit. People know each other very, very well. And one of the issues that we raised in previous discussions was, for instance, the way the... sorry, yeah.
I understand the arguments for it. I hear that well from your current and earlier responses. I suppose what I'm trying to get at is how it would work in practice if this bill before us was amended, and why the current provision that the courts have to provide anonymity, why that is insufficient where women and girls are either the victims of FGM or are at risk of being victims. So there's, the government will say that the law, the existing law, provides for the court to grant anonymity. I'm asking you why that's insufficient, in your view.
If I'm perfectly honest, I'm not entirely familiar with these 4 conditions. We based our response entirely on, with regards to this particular type of abuse, what we thought would be the most appropriate course of action as a standalone process, if that makes sense.
Just wondered, Ms Mcleod, do you have anything to comment on this particular issue?
I'm a bit like Angela in that the actual details of the law, I wouldn't be the best person to inform me on that, but the point that you were making there came up very strongly. There was a case recently, I think it was in Bristol, and it was a Somali family. And people in Glasgow knew who that was by the way the media reported it, although no names were mentioned. And the other thing that people said was that social media, they just really didn't see how... they couldn't imagine how you could construct any additional legislation that would actually stop the spread of information on social media, and how quickly that then goes from one country to another. And it does have implications, your family back home could get threatened or all sorts of things. So how you would actually ensure that, I'm...
Okay, well maybe that's something we'll, perhaps try and bottom out with the government. Ms Spears, given that your organisation supports the training of social workers, I wondered if you had any views about whether or not it would be useful for the children's hearing system to be able to grant an FGM protection order or not.
I think if one ends up existing, I would agree with that being part of the powers of the reporter and the children's hearing system. I think that would be a really useful coexistence, I suppose, with the other orders that are available to the reporter. If the protection order goes forward, I would say yes. Just because, for all the reasons that was stated before about, and that Andy mentioned about the benefits of the children's hearing system, not taking children and their families further into the judicial system than they need to be, and into courts, etc., that's, again, a more supportive aspect. So I would say yes. I don't know if people would agree.
Thank you. Thank you. Thanks, Convener.
Fulton.
Thanks, Convener. Thanks, panel. It was just following up from questions in the previous panel. It would heard a wee bit about from the academics that were there, weren't sure about how prevalent FGM is in Scotland, and certainly from earlier engagements that I've had, that would seem to be the case. There's maybe not a whole body of evidence. From your work, you're on the front line, a lot of your services are on the front line. How much of a prevalent issue is this in Scotland? And just to combine the questions in the interests of time, as I also asked the previous panel, do you feel that this bill, if we don't get the engagement right with the communities, has the potential to make it even harder to reach people and push it, the practice even more underground, for want of a better term?
I agree completely with that. In terms of our direct practice, we're in the business of building relationships with people who are vulnerable, and at MCFB that can be vulnerable for lots of different reasons. But if we ignore some of the fear that would be attached for communities and for individuals, if we don't recognise that would be the case, then I think we're very much in danger of driving practices underground, alienating our services from communities, and not offering, not being able to offer support to people who really need it. And they may, if they're fearful, we already work very hard to engage with people, and if they associate that engagement with some sort of accusation or insinuation of criminal behaviour, then we're on a really sticky wicket there.
I would agree as well that we do need to get it absolutely right, because the last thing we want is to perpetuate that fear of engagement with not just statutory services but any kind of service. But going back to your question about prevalence, I think that really is the golden nugget, and unfortunately I don't think there is an answer, partly because a lot of the numbers that we do have actually come from maternity services. Now, it's not essential that every woman who's a survivor of FGM is going to access maternity services. So a lot of the ways in which we try to estimate what kind of numbers we may or may not have is through extrapolation, based on sort of census information and prevalence in countries of origin, if that makes sense. But we also need to be aware of the fact that for women who will not access maternity services, are other professionals aware of what questions to ask in order to establish whether FGM is present? And that includes not just health professionals, but teachers, social workers, people working in services across the board that people are likely to access.
Nobody can say for sure what the numbers are, but we have one Glasgow-based project, Rights and Choices, which is not an FGM-specific project, but it works with asylum seekers and refugees and migrant women. And I would say about 70% of the women there have undergone FGM. A significant number of them would have had type 3. And we regularly, like month in and month out, come across women who've been in touch with services who've not been asked the questions or given the information that's allowed them to talk about either physical or mental problems, health impact rather, and problems possibly in the family, some possibly relating to child protection. So there's definitely significant numbers of women and families who have been affected and who could have more negative impacts that are not being reached. And I think that I would agree we need to continue. I think we've made a big difference in awareness, certainly in the Central Belt, but we need to continue that. And I think like the answer to trying to get a better idea about prevalence and to improving that engagement would be to target your resources at key points of contact. Not everybody has children, but everybody should have a GP. Women should be part of the national smear testing programme. So registration with GP, the smear testing programme, certainly maternity services, but also when children go to nursery or school, is there an opportunity there for including something in every parent's pack of information or engaging at that very early stage so that we start to build up a better picture. and it's particularly important, I think, in parts of the countries where the populations at risk will be very, very low. But if it does happen, it could have a catastrophic effect for girls. In relation to the sort of argument about whether it will drive it underground, I think the law itself shouldn't if it's brought in, but if it was badly applied in the first instance, it certainly would, and I think it's going to require some sort of skill and training to make sure that in the early days, I mean, my view would be that if the first orders that were placed were seen as that family was just planning to go on holiday, then that would have a really, really, really negative impact, and it would have unexpected negative consequences. And a point that was made quite strongly by a woman at one meeting was that if the family really, really want to do it, they would send that girl abroad and just not bring her back. So, do you know, I mean, families, if they really wanted, if they were really committed, they will be able to do that anyway. But I do think the legislation could usefully protect other young people.
Said now, regarding the prevalence, I think it's very hard to know. For example, like myself, who is working with men, it is very hard to know. And for example, like we had a workshop 3 weeks back where we had a number of communities, and there were 3 from the Yemeni communities, and they were arguing with us that there is no any FGM in their country. There is not even 1%, though there is kind of 23% is practiced there. And maybe it took us maybe half an hour just arguing with them and showing them through the websites and some Googling through their own country. So we showed them something from their newspapers. They said, no, this is newspaper, so we don't rely on that. And we were able to get some other resources also from their own country. They still were adamant that there is not even 1% in their country. So it is very hard if this kind of people are there, if they don't know that it is happening in their own country, maybe here also could happen and they don't know it. Even it is the same true, like for myself, I have 2 daughters, for example. I didn't know what happened. That it's only when I was engaged in this kind of thing that I knew that FGM has occurred to them, because in our communities or in our culture, mostly there are some cultures where men are involved, but mostly it is through the woman the things are done. So you don't necessarily know that this is happening, so it's very hard to know about the prevalence. And the other question is whether the protection orders will lead people to go underground. Yeah, this is yes and no. The protection order could be empowering to people, where it will be, you know, it's kind of, if it is done correctly, that means, as Jan was saying previously, there are so many people who perceive the things as a religious thing. For example, in our project, what we do is we bring some imams for Muslims, and we do some, you know, priests as well. So we educate the people, because there is a kind of wrong interpretation of some religious sayings, for example, in Islam, where it seems as if it is acceptable in Islam to accept that. So what we do with people is we bring some religious men who talk to them, as well as we give some examples. For example, we say Yemen, who is Muslim, and Saudi Arabia, who is totally a Muslim country, nothing is happening there. Though if it was something related to Islam, then Saudi Arabia would have been one of the countries which, you know, does the things. And like North Africa, for example, they are predominantly Muslim, but they are not practicing except in the northeastern country, which is Egypt, which is more than 90% is practiced. So it will be a blessing. The project will be a blessing if it is done properly through, you know, like empowering the communities and, you know, awareness raising. It needs a lot of work. We should not rush to just the protection orders, because it might give a negative impact on that.
Thank you.
Just while we were talking about the protection order specifically, did panel members have a view on what length of time they should be?
I think it would need to be very flexible, potentially quite long term, but
sometimes it's helpful for us to understand a scenario or a circumstance, so that it can seem a bit abstract just talking about them out there. Can you think of an example of women that you've worked with, and what type of intervention would have given them that protection or space to take action or to...
probably competing with my colleagues here to give you examples, but yes, we have examples. There's one with a woman that was referred to us as a survivor and was receiving support from us, who then went on to declare that she had a fear that FGM would be performed on her 2-year-old when the family returned after a period of study. They were in the country on a study visa, so that the 2-year-old of the family would be at risk, and this had been declared probably to be the case in the plan for extended family back home, and that her husband was at best ambivalent about this, because he saw this very much as a tradition that, as you say, that he didn't feel he had much part in, but it just was something that was going to happen. So my colleague who was working with an FGM support worker worked with the women quite closely to the point at which we felt that the child was at risk and that the woman had very little agency in terms of her setup to be able to do anything to protect the child. And at that point we involved our statutory colleagues, as we would do, following GIRFIC guidelines. And the family then engaged with specialist social work services, in this case asylum and immigration. And in a voluntary way, the family went forward, still engaging, because there was a 6-year-old in the family, little girl who was an FGM survivor. The woman was an FGM survivor. She had male children, and she was in great fear. Her issues for her were, she came from a relatively affluent, well-educated family. She lived quite comfortably while she was here with her children. They were settled in school in Scotland. The prospect for her in pursuing the protection of her child, which was her #1 priority, was that she would, in all likelihood, lose her husband, who would go back home without her. He may attempt to take the children, but there was secure arrangements made for that not to happen. But certainly she would be abandoned, in her view, in a country that wasn't her own, speaking a language that wasn't that familiar to her, although she could speak English. Her children, the city that they were in wasn't Glasgow, but her family would be uprooted. Her children would be taken from school because she would have to seek asylum, and they would be moved to Glasgow, and they'd be accommodated in Glasgow, where they knew absolutely no one, and the children would be taken out of school and nursery, and that would be the result for her, and she would be on her own in Scotland, which she hadn't chosen to come to in the first place, in order to protect her child. And I suppose that for us is where we'll talk about protection and support. Now, a little bit of breathing space of a protection order in the first instance would have given perhaps her some time to think about her options with some protection. I don't think they would have changed much of her options because of the concern that we've all expressed about the interface between protection orders, the legislation that we may have in Scotland, meeting Home Office legislation. So there's potential, hypothetically, for that woman's immigration and asylum situation to change, and asylum to be denied to her. And she would have been an abandoned woman going back to her home country with her children, and all that we would have done was increased her vulnerability and the vulnerability of that child. Mm-hmm. That's...
How would a protection order make that better?
That's actually a question I came here with. I'm sorry not to have an. I know that sounded like a very well-rounded case study, but that's the question I came here with.
I think it is the key question, and it's one we'll certainly put to the government. Does anyone have anything else to add on that question?
That is the scenario that I would have picked, because, well, I gave you the other example, and that's the most common sort of referral that we get where there's quite urgent child protection concerns, you know, and as I said earlier, especially when the family are stating that plans are definitely in place and it's not just a theoretical risk. I think the answer is that an FGM protection order might only help in that it might help win an asylum claim, but how it will help with the impact on the family is possibly not at all, because it's support that's needed.
Sure, thank you, that's helpful. Mary Fee.
Thank you, Convener, and can I thank you all for your evidence. It's been very, very helpful today. I wanted to ask one of the questions asked in the previous panel, and that's around guidance, because whatever guidance comes with this piece of legislation will be incredibly important. And as a committee, we can make suggestions as to what we would like to see in that guidance. And I would be really keen to hear your thoughts if there is something in particular that should be included. And perhaps if I could start with Mr. Darasai, because I was particularly interested in some of the comments you made earlier about the work that you do with men in communities, because I think we can't exclude men in communities from any of this, from the learning and the education and the support that they can give to families. And I appreciate we don't have a huge amount of time, but I would be keen to hear if there is any areas of good practice that you know of in your communities that we could perhaps recommend that should be included as part of the guidance. And if you can't go into all of the detail today, I would be grateful if you could perhaps contact the community, the committee, and let us know. So if I could perhaps start with you and then move on to the rest of the panel.
Well, we have discussed this one actually in a group, as well as when some people from you visit us. The guidelines are actually, they are a little porous and they are not so clear. First of all, there is no any clear indication what the guidelines are, whether the third sector will have their own guidelines. So we put something in writing. I think we send it to issues, for example, like what we said is the people who can make the FGM protection, for example, it was not so clear. One of the points where they say any other person, but only with the permission of the court. So we were not clear of this. What do this mean? So in order to know this, I think we need some answers for that. If we don't have those kind of answers, I think it's very hard to know about it. And there should be some examples of what triggers, for example, the protection order. For example, if, like Jan was previously saying, in FGM, for example, you could say if a girl is going for a longer period of during summer, then this could give an indication that something might happen, but it could be even shorter time. So there are so many things, and we were asking also that if there are some scenarios from other, parts of the UK where it can help us to work on it. But we work with different cultures actually. For example, there are some of men come from the Middle East who are Arabic-speaking people. There are some Kurdish, and we deal with different people from East Africa, from Somalis, Eritreans, Ethiopians, Sudanese, and some Egyptians as well as from West Africa. So we have, we can, it's very challenging. Those people who come from East Africa, they mostly depend on the religious teachings. They say this is something, especially the type 1 FGM, they say this is a religious requirement, where in the West African it is mostly cultural things. I think it needs more time. Maybe I can feed on the question a little bit. Yeah.
That'd be very helpful, thank you. Ms. Spears or
I suppose my view about guidance is slightly influenced by our training role. I think that if guidance is issued, it needs to be accessible to be trained on, to be utilised for training purposes. And I suppose, as you would expect from the third sector, we would say, could that please be resourced? Because we can't carry the burden of that training. My previous role was a learning and development advisor, so I understand the importance of training as it comes down through the statutory sector to the workforce, but in the third sector we sometimes end up carrying that burden ourselves. Angela and I worked in partnership, and very much a big part of the Bright Choices initiative was around being able to offer local authorities advice and training and support in relation to a number of the topics that we've covered today. But I would say any guidance that is issued needs to be resourced in such a way that it can be disseminated. I don't know if you would agree with that.
Okay. No. Do other panel members have a view?
I think the existing guidance has got a lot of really helpful information on it that, you know, can be built on. I think improving practice skills, we obviously need to keep doing general awareness and promoting the new legislation if it does come into force. But I think there's a lack of practice skills. Like, how do you ask the question? And are people clear why they're asking it and what should follow from a positive response? So something that would get key organisations to have regard to developing appropriate skills at key points. And again, I think like GP, maternity and entry into education are things that surely every family will do one of them, you know, if they've got kids. Well, they would have to do maternity, wouldn't they, if they had kids? But concentrating the resources, I think, because just saying, oh, we should do more training, it's not going to have any impact. And as well, I think, I'm not sure how this could be done exactly, but highlighting the importance of carrying out community engagement, even if that is just on the level of engaging with organisations initially, so that practitioners are aware of organisations like the Kenyan Women Kwiza, the My Voice project, you know, the other projects that have probably submitted evidence, so that you've not just trying to talk to the communities when you've got a crisis, but that the communities are able to inform. And the reason work that was done in Glasgow about engagement was really informative, and looking at the good practice guide that came out of the ROSA funded multi-agency initiative has got really strong and clear guidance for community engagement, and I'd really recommend that. And one of the things that they recommend is like highlighting positive change, because African communities have demonstrated that they can change attitudes to FGM, and that FGM has it's not a simple story, but we have seen significant fall in prevalence. And if this initiative could be linked to positive change, positive community-led change, I think that would go a long way to helping to avoid possible negative consequences and a bad start to the legislation.
Okay.
Dad?
One thing actually, you asked for specific examples that could be used to inform any further guidance. The Edinburgh Child Protection Committee, I think it was either July 2018 or 2017, published the interagency procedures for the protection of girls and women at risk of female genital mutilation, which has been absolutely instrumental in our work. It's been a very supportive, very detailed and very informative document, which actually, as Hassan said, it has been so helpful because it breaks down the specific responsibilities by professional. So what would a health professional do, a social worker, a third sector worker, and so on? It's very, very clear as to what is expected to be done. So I would highly recommend that in any consideration, that would be a document, a really good document to consult, actually. So that's really kind of all I wanted to add to that.
That's very helpful. Thank you. Thank you.
Okay, well, can I just thank you all for your evidence again. It's been very helpful. We're grateful to have you here. Our next meeting will be continuing to take evidence on the Female Genital Mutilation Protection and Guidance Scotland Bill, and we're now going to move into private session.